I'm going to share the slides, so hopefully you should be able to see my PowerPoint.
Yep.
Just admit those people. Bear with me a second. Okay, right. So as I said, I'll send the slides around afterwards. I've done quite a lot of detail on the slides so that you should be able to use them later if you want to, and hopefully avoid taking notes. I've decided to go in quite some detail. So I'm going to cover the whole, everything. I said it all you need to know. So I'm going to start right at the beginning. With what Article 2 is, what it says, what the ECHR say about the various limbs of Article 2, and then eventually we will get to how that relates to inquests, whether it makes an enormous difference or not, which is still a subject of quite some debate. So starting off then, sorry, I just need to admit these people who are coming in. So starting at the very beginning, the basics of Article 2. I'm not going to read this out to you. I just thought it would be very helpful to have at the outset. I just need to get somebody there because I can hear a bit of echo. If anyone arrives and isn't on mute, could you just please put your microphone on mute to save getting feedback? Thank you. So I'm not going to read out what it says here, what Article 2 says. I'm going to go through it piece by piece. All I'll say is that the vast majority of what I'm going to talk about all arises from the first sentence of the first paragraph of Article 2. The second part relates to the taking of life, which only really arises in cases of killings by the state, usually by police officers. And I will come on to that briefly, but most of what I'm going to talk about is in relation to the first part of the first paragraph. Before we get anywhere else, I thought it'd be helpful to have a look very briefly at jurisdiction. It can be a complicated issue because I'm not going to get into it in great detail, but the simple point is primarily Article 2 applies in the UK. However, where the state through its agents is exercising authority and control over an individual, it can be international. Now that in this case was about the snatched Land Rovers, and it did apply to the soldiers who were on operations in Iraq. So if you do military work or anything like that, then the simple point is, yes, it applies, provided that there is sufficient control. Limbs of Article 2. Very simply, the first limb is what we call the negative limb, not to take life. The second is the positive limb, which is to take appropriate steps to safeguard lives. That has different aspects to it, which I'll come back to in a second. And the third is the duty to the investigative duty or the procedural duty, which is the most relevant one to inquests. And the important point is the procedural limb, which is what changes the nature of an inquest, only arises where there is a potential breach of either the negative or the positive limb. So in order to understand when it applies, we really need to understand what the negative and positive limbs are before we get to the procedural limb. So the positive obligation, as I said, it is split into parts. The first part is the systemic duty, and that is the duty to have in place a regulative framework, and I'll come back onto what that means in more detail in a minute. The second part is the operational duty, which is the duty to take preventative measures where there is a known risk to an identified individual. Again, I'll come on in more detail to what that means in just a second. So that systemic duty in more detail, what that requires of the state is to have in place effective provisions to deter criminal offences, appropriate administrative and legislative steps to protect life. So, for example, the provision of a police force and a criminal justice system and an effective health system, and I'll come on to what that means in a bit more detail later on. And this can include taking reasonable measures to ensure the safety of individuals in public places. And we'll come on to that in terms of natural disasters and things later on. The operational duty arises, that I've referenced Raybone here, but it's the most helpful case on this because it reviews all the authorities and sets out very clearly what the test is. And the operational duty arises where there's a real risk and an immediate risk to a particular individual, and a real risk has to be substantial or significant, and immediate means present at that time and not at some time in the future. And in Raybone, which lots of you will be familiar with, the deceased was given home leave from her informal treatment in a psychiatric unit, and the risk was the risk of suicide over that weekend. So immediate doesn't mean in the next 5 or 10 minutes. It can mean over the course of a couple of days, as it was in Raybone. It has been said in this case, Van Col, that that's a very high threshold, and that can be quite a useful quote. I suppose a useful quote if you are acting for someone who doesn't want Article 2 to be engaged. So I thought, because it's often difficult to explain all of this and how it all fits together, I would try to create something to demonstrate what this means. So the right to life is protected by law. Now that means, first of all, as I said, there's substantive duties not to take life. That seems pretty straightforward, other than in certain circumstances. But there's also substantive duties to act positively. And there's two ways in which that positive duty arises. One is the systemic or regulatory duty. So that is to have systems in place, to have an ambulance service, to have doctors, to have police, that kind of thing. And the second is the operational. And that is where there is a risk to an identified individual, the duty to act to protect that individual. If there's a potential breach of any of those, in those circumstances, the state's procedural duty is engaged. And what that means is that the state has to investigate the death to see whether there has been any breach of these substantive duties. I'm going to deal with each of these in turn in a little bit more detail now. So I'm going to look at the obligations in context rather than simply sticking to the systemic and operational duties. I'm going to look at it in terms of where these arise and what they look like in the actual contexts that we deal with. So the first of those is in terms of homicides, and the operational duty in homicides can arise in various contexts if there's knowledge, or if the state knew or ought to have known of a real and immediate threat to the life of an individual. That has arisen in all sorts of contexts, including prisons, the risk to witnesses in criminal proceedings, domestic violence, and one particularly helpful quote is on domestic violence. The ECHR has said that the state should take due account of the particular context of domestic violence and the recurrence of successive episodes of violence within the family unit. So what that really means is if you have repeated ostensibly low-level violence within a family unit that is progressing, then the state has to take due account of that. And what we know is that that often develops into a risk or a threat to life. And that is relevant in terms of when Article 2 is engaged in a domestic violence sort of setting. Systemic obligations can arise in homicides. There's a case at Mastro Matteo where a prisoner was on leave, and the argument was about the system for allowing prisoners to go on leave. Now, in that case, there was no breach, but Article 2 was engaged in the sense that the ECHR was willing to look at the issue and considered that having a reasonable system for a prisoner on leave was something that was required by Article 2. Murder by an off-duty police officer. In that case, the police officer was armed, and the police systems for assessing whether the officer should be permitted to carry a weapon were inadequate, and he wasn't an appropriate person to do that. The Tagayeva case is an interesting one where it arises from the Beslan siege, and there was a breach of Article 2 because the state knew about the risk of an attack. Now, because they didn't know about the risk to identify the individuals, it didn't engage the operational duty, but it did engage the systemic duty because they knew so much, and the system in place to deal with that information and prevent the terrorist attack just failed. Self-harm, one that arises often, and I spoke about last week, for those of you who were around in my seminar on suicides. The operational duty in self-harm cases will arise, and this is again that Raybone case that I spoke to you about before, where there's been either an assumption of responsibility for the individual's welfare, and the paradigm example there is state detention, but it's important to note that it doesn't only apply in state detention. It applies wherever there is sufficient assumption of responsibility, or in circumstances of sufficient vulnerability. And Z in the UK was a case where they failed to protect a child who was at knowledge of the state was at risk of abuse. So there's no simple answer to when it can arise. It really is a question of assumption of responsibility or vulnerability. The risk has to be an exceptional one, not an ordinary one. The risk in Stoya Nova was the risk to a member of the armed forces who was parachuting, and that was an exceptional risk, not an ordinary risk of everyday life. But if you get past those, Raybone spoke about whether the operational duty was engaged, and it was engaged in Raybone because the deceased was vulnerable and there was an assumption of responsibility. She wasn't detained under the Mental Health Act, but the Supreme Court said that wasn't particularly determinative, not least because she could have been detained under the Mental Health Act, and if she had deteriorated, then she probably would have been. So the court felt that that distinction was rather artificial, and the point there was that she was sufficiently vulnerable. In a more recent case, the case of Lee, that raised the suggestion of whether the operational duty could apply to a patient in the community. Again, that's something that I have argued in front of a coroner before, a recently discharged psychiatric patient, where there is still a significant degree of control because that patient can be readmitted. If there's sufficient vulnerability, then I don't see why a patient in the community couldn't engage the operational duty under Article 2. Depends on the circumstances. So next to talk about healthcare, and now you notice I haven't talked about the systemic duty in terms of self-harm. And the reason for that is because the systemic duty I'm going to talk about generally in terms of healthcare, because it applies equally to psychiatric care and to physical care. The simple starting point for this is the case of Fernandez, which was a 2018 case in the ECHR. The ECHR set out very clearly that there is a duty to have in place a regulatory framework compelling hospitals to adopt appropriate measures for the protection of patients' lives. Now, appropriate measures really means policies and procedures. It also includes an obligation to ensure the implementation of those measures, including supervision and enforcement. And perhaps most tellingly and most usefully in terms of what this really means, matters such as an error of judgment on the part of a health professional or negligent coordination, so a simple failure to pass something on from one person to another, for example, is not a breach of the systemic duty. It has to be more than that. And the ECHR set out the types of case that would be sufficient to be a breach of the systemic duty. The first is where the patient's life is knowingly put in danger by someone denying them access to life-saving emergency treatment. Now that sounds like a lot of essentially simple negligence, but they clarified that by saying that the acts and omissions must go beyond a mere error or medical negligence. And in fact, they said that there would have to be a breach of professional obligations. So I think what they're really talking about there is gross negligence or something of that level. So simply failing to diagnose whatever condition it is and therefore to treat it and that leading to death is not enough. It has to be much more than that. The second type of case is a systemic or structural dysfunction, which is really what we saw on the previous slide, which gives rise to the patient being deprived of access to emergency treatment. Now, this is a high threshold, but I would say the points to remember are that dysfunction doesn't have to be at the level of the Department of Health. It can be at trust level. But it does have to be structural. So if there's a policy and procedure in place that is capable of protecting life, but it's not operated in the correct way, then that's not going to be a breach of Article 2. Just bear with me a second. I've put two examples here. They are Takushi and Humberstone. Both on the underlying cases were about the operational systems of ambulance services. They were Article 2 structural systemic breaches. They both predated Fernandez, but I think that they would. I think that they would, even following Fernandez, be found to be breaches of the operational duty, because the problem in those cases were the systems of the ambulance service, which those of you who dealt with those cases will know they have very complicated algorithms for the assessment of patients, and then people are involved in distributing the resources. And it was those systems that didn't operate in those cases, not individual decision making. So the important point to consider is the structure, the policy, the process, not how it was operated on the day in question. So there's quite a few ECHR cases on in environmental and industrial deaths. I'm not going to spend a huge amount of time on them because they don't arise so often in the UK, because we have a reasonably robust health and safety regulatory system. But the court has said that the state has to have in place a system of regulation to protect the health and safety of individuals. That system has to give adequate information to the public. There's a case on that, and I'll come on to in a second. It has to have procedures for identifying shortcomings in the safety processes, measures to deal with natural disasters, and if the state is organising the dangerous activity, this arises quite specifically in military cases. So if the state's organising an exercise or a live firing, whatever it might be, then there is an Article 2 obligation on the state to ensure that the risk is reduced to a reasonable minimum. So essentially a duty to take reasonable care. But that only applies where the state is actually organising the events. So the two cases that arise under this are Onyel Ildiz, I'm probably not pronouncing that correctly. That was where there was a rubbish tip which exploded because of the methane wasn't being vented properly. And there was a failure to give information to the public about the risk or to take steps to prevent it. And in Budieva, that was where there were a number of deaths due to a mudslide, and the mudslide was due to a failure to implement appropriate land planning and emergency relief policies. In terms of accidents, there's a similar obligation to adopt regulations and ensure the effective functioning of those regulations. Again, not something that arises terribly often in the UK. Relatively briefly, I'm going to touch on the negative obligation, as I described it at the very beginning, which is not to take life. The reason I touch on it briefly is because it's a a huge topic in its own right, but in some ways it's actually relatively straightforward because it's a question of what's reasonable in the circumstances, and these are usually the cases around shootings by police officers. The interesting things I wanted to note were that the ECHR has said there should be a framework defining the circumstances in which they may use their force and firearms. Adequate training and vetting of armed state agents. Now that arose in that case I referred to a few minutes ago with the off-duty police officer. There has to be adequate planning of any operation. The force used must be proportionate, but the ECHR will take into account the fact that police officers are acting in the heat of the moment. So that's what they've had to say about those. The next issue is the investigative obligation, which, as I described earlier, is this here on the right. If there's a potential breach of any of these, which I've just spoken about, then the state's procedural duty is engaged, and the state has to undertake an appropriate investigation. So what is the obligation? And this is important and a very useful quote, I think, for, excuse me just a moment. So the obligation is to initiate an effective investigation by an independent official body into any death occurring where it appears that one or more of those substantive obligations has been or may have been violated. Now this, if I'm doing written submissions Article 2, I almost always start with this because I think it is the clearest and the most succinct explanation of what we're really talking about when we talk about an Article 2 inquest. So we're looking for one of a breach or possible breach has been or may have been of the substantive obligations, and the state then is obliged to initiate an effective public investigation by an independent official body. We'll break all that down in a minute as to into what that might mean. The purpose of the investigation, and this is Jordan and UK 2001, again, a very, very important case and worth having to hand if you're doing Article 2 cases or Article 2 submissions. The purpose of the investigation is to secure the effective implementation of the laws which protect the right to life. So it's really to give some weight to the obligation to protect life. So because if the state isn't investigating where life has been lost and the state might be involved, then the state can't effectively put in place measures to protect life in the future. So that's really the purpose underlying the investigative obligation. Jordan set out quite clearly some minimum requirements that have to be met in order for the Article 2 investigation to be sufficient for the purposes of Article 2. It has to be independent from those implicated, not only hierarchically or institutionally, but also practically. So it should be, so that's why we have a coronal system. It's judicial, it's independent of the other bodies. So it's not a trust SUI or something like that. It has to be properly independent. It has to be effective, capable of leading to a determination in Jordan of whether the force used was justified. But in other cases, it would be a determination of what happened and why, and to the identification and punishment of those responsible. The important thing to note there is identification and punishment. Obviously, in inquests, we don't deal with punishment. We may deal with identification, and I'll come back to that in a minute. But the important point to note here is this is beginning to give us an indication of the fact that this can be done by various means. Sometimes the criminal process that results in punishment will be enough to satisfy Jordan. More often it's going to be the inquest, and that's obviously what we're talking about today. There has to be a sufficient element of public scrutiny or its results to secure accountability in practice as well as in theory. The next of kin of the victim must be involved. that is what led to Humberston, which is the case on legal aid for Article 2 inquests. And both of those I'll come back to in a little bit more detail in a second. The case of Al-Skini, which is about abuse of Iraqis by the armed forces in Iraq, indicated two other important points: that merely awarding damages is not enough, because of course the point of the Article 2 investigation is to find out what happened and why, not to simply compensate someone for the fact that it's happened. And also importantly, that the authorities should act of their own motion. It shouldn't be left up to family members to act, which is satisfied in the UK, of course, by the fact that the coronial investigation is an active investigation. So that's the theory. How then does that apply when we get into an actual inquest? So, well, first of all, we return back to Middleton. And in Middleton, it was said that an inquest is the means by which the state ordinarily discharges that obligation, save where a criminal prosecution intervenes or a public inquiry is ordered. So the point is, as long as the investigation meets those minimum standards I just set out from Jordan, it doesn't matter whether it's a criminal prosecution, public inquiry, or an inquest. Obviously, we're talking about inquests. If there's been a public inquiry, for example, the Grenfell inquiry is likely to satisfy Jordan. There may be some arguments about that at a later date, remains to be seen, but that would be enough. If there's a criminal investigation and it's led to a trial, that's likely to be enough. And then there's often arguments then about whether it's necessary for the coroner to reconvene the inquest. I'll come on to that in a moment. But it can be done in a number of ways, and as we all know, the CJA Section 5 was amended to include the relevant additional words where an Article 2 is engaged, which are that the questions are extended to include in what circumstances the deceased came by his or her death. And I'll come on in a minute to what that means in practice. So in terms of the practical implications, the first and perhaps most significant for many of you is going to be funding. Again, ECF funding is a specialist topic in its own right. I don't profess to be an expert on it. I'm very grateful for my instructing solicitors for being able to navigate it and get funding where appropriate. Humberston is the leading case. Some useful guidance there, if you've not seen it before, that the decision by the legal aid agency must focus on the effective participation of the family. They must be involved to the extent necessary to safeguard their legitimate interests. That's one of those sort of helpful and rather unhelpful tests, because it doesn't really say very much, it seems to me. Legal aid shouldn't be exceptional in an Article 2 inquest. And in terms of the right to question witnesses, it's often suggested by the government that the inquest is an informal process and you don't need representation. But Humberston makes the hopefully rather obvious point that it's very difficult for families to do that for lots of reasons, technicality, complexity, and of course emotion. So that's all quite helpfully set out in Humberston. Scope is the really kind of the big question. If it's an Article 2 inquest, how does that affect the scope? At first blush, because obviously there are additional words. The test in a non-Article 2 inquest is how he came by his death, and in an Article 2 inquest it's how and in what circumstances. I mean, those additional words seem self-evidently to be wider, but there's a number of cases, including this Kent case, that says the extent to which the two would differ is debatable. And I know there's lots of debate. Coroners often say to me when I'm arguing that it's an Article 2 inquest, well, what difference does it make? Well, the difference in some cases is bigger than the difference in other cases, is the simple answer. The reason for that is that the how that's already there affords a very wide discretion. it isn't just the last link in the chain. It's not just the mechanism by which the death occurred. We know that. It is often going to consider event leading up to the death, contact with the police, contact with doctors, whatever it might be. So to what extent is an Article 2 any wider than that? Well, I think the simple answer is that often it's going to be about policy issues and resources issues. There are some cases where it would be difficult to persuade a coroner that the how should include policies and resources. But in an Article 2 inquest, I would suggest it's a bit easier to get to in what circumstances to include the resources and the policies in the background than it is in a non-Article 2 inquest. So it's possible that those types of issues might be within the scope of an Article 2 inquest when they would be outside of a Jameson. But I think it's true to say there are cases where the scope is actually no different between an Article 2 inquest and a non-Article 2 inquest. Part of the scope issue is the question of identifying the perpetrator. That's come up a couple of times in recent cases. The first one is this Hambleton case, which is the reconvened Birmingham pub bombings inquests that were quashed previously. There was an issue about whether or not the coroner should get into this question of who the perpetrator was. Of course, those of you who are familiar with it will know that the police over many years had failed to identify a suspect, or had failed to convict anybody, I should say. The divisional court said that the rule against naming somebody in the conclusion does not mean that the identity of the perpetrator cannot be part of the scope, which seems entirely reasonable and quite common. We see that quite regularly, that the identity of the person shouldn't appear in the conclusion, but that doesn't mean you can't look into it. And the Court of Appeal said that the scope relates to the four questions: the who, where, when, and how, including in what circumstances it was Article 2. But there's no legal duty on a coroner to undertake a further investigation simply because the police inquiries have failed to deliver a suspect for trial. Well, that seems to suggest that there isn't an obligation under Article 2 to investigate and to identify the suspect. But if we look at the next case on this, which is Finucane, Supreme Court case, this arises from the murder of a Catholic lawyer in Northern Ireland. There was an inquest, but it was very limited. There has throughout this been evidence of collusion by the government, by MI6. The inquest only considered the very narrow question of how. There's been various investigations into the murder over the years, judicial investigations, police investigations, that inquest. There's never been a public inquiry. The case went all the way to the Supreme Court. My internet connection says it's unstable, so I'll just wait a second for it to come back. So they went all the way to the European Court, said that the previous investigations were not independent or sufficient, and the government promised the family that there would be a public inquiry. There was a change of government, and the new government said, well, actually, no, we're not going to have a public inquiry because we don't want, I think it was the coalition government said they had a policy of no more endless investigations into Northern Ireland. The case went to the Supreme Court, who said there has been no Article 2 compliant investigation because they haven't considered the collusion issue, which was considered to be part of the perpetrator because it was the collusion which allowed the murder to take place. Now that seems quite different to what happened in Hambleton, but the two important differences here: previous investigations had not been independent or sufficient, whereas in Hambleton there'd been police investigations which had been extensive. And in Hambleton, those investigations had failed to find suspects, whereas in this case, there had been no adequate investigation of this issue of collusion. So when we put the two together, we really are taken back to the starting point in Article 2, which is that there has to be a sufficient investigation which is capable of identifying the suspects. If there have been exhaustive investigations which haven't been able to do that, then there's no need for the inquest to try again. But if there haven't been, then the state still has that obligation, and it may be fulfilled by the inquest, or, as I've said, by public inquiry. Other investigations, an issue that quite often arises is whether the coroner need reconvene an inquest where there have been other investigations, whether they be judicial, criminal, internal, whatever they might be. And Silvera is a useful case on that. It's a patient who absconded from a psychiatric unit and she murdered her mother. She pleaded guilty, so there was to the murder, so there was no Crown Court trial. There were various investigations, internal NH Trust investigations and a Home Office domestic homicide review, both of which sat in private. The court found there that the minimum standards in Jordan, also repeated in Edwards and Armin, had not been met because there had been no independent investigation and there'd been no public investigation. So for those reasons, the inquest ought to be resumed. Now, this is quite useful in those cases where you might have investigations which have, to some extent, identified the facts of what happened, but you really want that inquest reopened. This is quite a useful case for that, because it points out that just because there's been investigations, if they're not public and if they're not independent, then the inquest should still be resumed. Perhaps one of the most significant effects of Article 2 in an inquest is on the conclusion. There's various different cases on this that say different things. I think the most helpful is in Middleton, where it is said that to meet the procedural requirement, the inquest ought ordinarily to culminate in an expression, however brief, of the jury's conclusion on the disputed factual issues at the heart of the case. Now that, I think, is the most helpful 2, 3, 4, 5, 6, 7, 8, 9 words. And when one is looking or is arguing about what the conclusion ought to include or not to include, or what the jury questionnaire ought to include or not to include, this really is the key to me. It's usually fairly obvious to all those involved in an inquest what the disputed issues are at the heart of the case and what the peripheral issues are. Middleton went on to say, in some cases, a short form will be quite satisfactory, but it must be for the coroner to decide how best in the particular case. Now that sort of points in the direction that a narrative is more likely in an Article 2, and that is my experience, that a narrative is more common in an Article 2 than it is in a non-Article 2. Excuse me. But this just simply points out that it doesn't have to be that way. The example in Middleton was that in Armin, which was the prisoner murdered in his cell, unlawful killing would have been an adequate conclusion, in a sense that it would be a proper conclusion, it would be right in law, but the real issue at the heart of that case was, how did this prisoner come to be sharing his cell with the murderer? That was the issue at the heart of the case, and in that case, a conclusion of unlawful killing clearly would not record the conclusion of the jury as to that issue. The Supreme Court of Middleton said that it would be helpful to consider these issues, where, when and how the defect in the system, where, when and how, with the 3 questions, and also the defect in the system which contributed to the death, and any other factors which are relevant to the circumstances of the death. So that's another helpful extract that you can use in terms of persuading the coroner as to what should or shouldn't be in a conclusion. So in terms of the form of the conclusion, as I've said, a narrative is more common in an Article 2 case, but the first question is, what is or are the central issues? Another way to put that is perhaps to look back and say, what's the possible Article 2 breach? If Article 2 is engaged on an operational basis, the central issues are less likely to include systems and procedures and systemic issues, so they're probably less likely to be included in the conclusion. Once you've identified what those issues are, does a short form conclusion adequately record that? If I'm from the family, I always say no, but it depends on the circumstances. The guidance 17 says frequently a narrative will be required. And although it doesn't say not always, I've added that in. I think that is absolutely right. It doesn't always require a narrative. The next issue is a slightly more contentious one, particularly very recently. And that's the question of whether the content of that conclusion, presuming that we are having a narrative conclusion, whether it can be judgmental or whether the language can be critical. Middleton, and these are the words that are always relied on in order to get that in, get judgmental words in, says a judgmental conclusion of a factual nature directly relating to the circumstances of the death. And the guidance 17 includes a list of words, although those words don't come from Middleton, they seem to have been inserted by the chief coroner. But that's what everyone always relies on to get this judgmental language in. I'll come back to that in a second with the very recent case that's just been decided this month. Causation, Article 2 has a potential impact on causation, which is that in Lewis it was said that the coroner has a power to leave matters to the jury if there's evidence upon which they conclude that the act or omission was possibly but not probably caused it. Now, this important point is that it's a power, not a duty. And the reason this exists, I think, is because the Article 2 obligation is not just in relation to that death. It's about upholding the right to life, and that can include what we might ordinarily think of as prevention of future death issues. And I think that's what, of course, we're saying in Lewis, is that it's not wrong, if the coroner decides to do so, to include those issues in the conclusion. Something in Jordan that was said about the burden of proof. And in that case, that was a case arising, it's the same Jordan that was decided in 2001. There's been an awful lot of appeals about this same inquest. The coroner was unable to decide, having heard extensive evidence, was unable to decide whether to accept the police version of events or that of some of the other witnesses. The Court of Appeal said in an inquest it's permissible for the coroner to be agnostic, that's their word, so to be unable to decide, because we don't start ordinarily with a burden of proof, and the coroner has to decide on the balance of probabilities what happened. And they recognise that it is possible for the coroner to be unable to do so. Now, in that case, the Court of Appeal said that the coroner may resort to the burden of proof that lay on the police and the state to provide a convincing explanation for the use of lethal force. Now, that I don't personally think that will apply in anything other than the example of a killing by a police officer or by an agent of the state, because that same burden simply doesn't exist in a hospital death or in a suicide in prison or something like that. Admitted failings. Tainton, again, is a case that's often referred to, which appears to indicate that a jury should be directed to record admitted failings even where they did not contribute to the death. That seemed to be pretty well fixed, the position, until this case of Smith, which I've given its own section partly because it's very recent, but also because it's quite significant. This is a case of a suicide. The Trust's RCA investigation, found that there was inadequate medical cover for home treatment team patients, and this is someone in the community. The coroner got an expert report that was highly critical. And in fact, the expert concluded that but for the failings, the deceased would not have taken their own life. And the coroner didn't accept that. And in fact, the High Court said that was quite reasonable for the coroner not to accept that conclusion, but that's not really the main point of this case. The point of this case was that the coroner included the criticisms that were admitted because they were in the RCA and they were also in the expert's report. The coroner included them in her findings, but because she wasn't persuaded that they led to the death, she didn't include them in the conclusion. The family appeal or judicially reviewed the coroner on the basis that critical findings of fact ought to be included in the conclusion, and they actually proposed, when they were invited to do so, proposed what that conclusion ought to say. I'm not going to read it all out, but what I would point out is it's not a million miles away from some of the conclusions that I've seen. I think it's probably would be one of the more critical, and it's probably a little bit optimistic if one were sort of drafting one's own conclusion. It has things like inadequate care, below the basic level, no opportunity to reach diagnosis, subtherapeutic dose. It's very critical, but it's not outside of what one might expect to see in an inquest, and that's what the family wanted. Interestingly, the court said, we cannot approve of language of this sort for either Part 3 or Part 4 of the record. Referring back to Middleton, which, as we looked at a minute ago, says it should be a judgmental conclusion, so why can't we have this critical language? Well, Middleton 37 does still say the prohibition in Rule 36.2, which is on issues of liability, etc., must continue to be respected. And the court in Smith said what Middleton envisages is conclusions of fact as opposed to expressions of opinion. And they said it was neither necessary nor convenient for those failings to be added. And they went further than that, and they said it would have been wrong to do so. In terms of this Tainton point, the court in Smith said that the argument that the failings ought to be in the conclusion is an argument of form over substance. So how do we reconcile Tainton and Smith? In fact, just before I do that, I just want to say, I think the importance of this in terms of Middleton is that it reminds us that the prohibition in 36.2 is still there, and that what Middleton envisages is conclusions of fact. Even though Middleton uses the word judgmental, it still has to be about the facts rather than opinion. And I'll explain, I think, what I mean by that in a moment. So non-causative failings. Tainton, in terms of trying to reconcile this, Tainton says such a statement, which would have been the admitted failings, would have completed the incomplete account of the circumstances in which Mr. O'Neill met his death. In Smith, it was said to be wrong and an argument of form over substance. So my view, and I think this will probably have to be argued out again, is that the way to reconcile them is to say that non-causative failings ought to be included if they are necessary to complete the account of the circumstances. Otherwise, following Smith, it is wrong to include non-causative failings in the conclusion, even though it's perfectly proper for them to be included, as they were in this case, included in the coroner's findings. And in terms of language, as I said, what Smith reminds us of is that Smith talks about a judgmental conclusion. We know that there's 4 questions are what they are. The Chief Coroner's Guidance says we can use words like inadequate, inappropriate, and insufficient. So it's difficult to see how those words are conclusions of fact and not expressions of opinion. So how do we square that circle? My view is that if we look back at Middleton, in Middleton, the House of Lords, as it then was, proposed a conclusion which was the deceased took his own life, in part because the risk of his doing so was not recognised and appropriate precautions were not taken to prevent him doing so. And they said this embodies a judgmental conclusion of a factual nature directly relating to the circumstances of the death. It is, although it includes the words was not recognised, which you might replace with there was a failure to recognise, this is still only factual conclusions relating directly to the circumstances of the death. And what Smith is talking about is going further than that and talking about things like inappropriate lacking, which start to edge towards opinion rather than fact. So actually, it seems that these words in the Chief Coroner's guidance might not be correct. And that wouldn't be the first time, I have to say, that we've seen the courts disagree with what's in the Chief Coroner's guidance. One final point is the issue of damages. As I'm sure lots of you will know, you can claim damages under the Human Rights Act against a public body if it breaches Article 2. In Jordan, the 2001 Jordan, which is the ECHR one, the delay in holding the inquest was a breach of the requirement of promptness. So then there were various proceedings, as I said, arising out of that inquest. The High Court of Northern Ireland found that it's obvious that unlawful delays will cause frustration, distress, and anxiety. And in this case, found that the unlawful delays were caused by the police service. Obviously, the police service being a public body, it was possible to have an award of damages. An award of damages was made against the police because in that case, the police had caused a delay, which was a breach of Article 2. The claimants in that case tried also to get damages against the coroner, but that failed for two reasons. One, because the delays were not the fault of the coroner, but also, importantly, before anyone gets too excited about issuing proceedings against coroners, Section 5.3 of the 98 Act basically gives judicial immunity other than in circumstances of unlawful detention. So that isn't going to be an issue. Now, in terms of questions, I know that there's been a couple of questions asked as I've gone along. So someone has asked me, what's the position likely to be in relation to healthcare professional deaths linked to COVID-19 in situations where there may be a lack of PPE? I understand that some coroners are requiring that health professionals' deaths linked to COVID-19. Well, I think the first point is that the provision of PPE, I think there could be no doubt that that would be a requirement of the systemic obligation under Article 2. The state has to have in place a system that's capable of protecting life, and that would include the life of health professionals. I think that system would include appropriate PPE. The state would have to take appropriate steps to do that, and that's where the difficult issues going to arise. We don't, I think, know yet the precise details of what's gone on in terms of that procurement, what steps were taken, at what point they were taken. But I think in principle, that could engage the systemic obligation under Article 2. Of course, the difficulty is always going to be establishing a link between the death of an individual health professional and the provision of PPE. It might be easier if they have no PPE, but even in those circumstances, it might be difficult to demonstrate that they that with PPE they wouldn't have contracted COVID. But I think in principle it does engage the obligation under Article 2. I can't see any other questions. Does anyone else have any other questions? If they want to unmute themselves and ask, please feel free to do so. Or if you want to put them in the chat, that's also fine. Alternatively, if you want to ask something that you don't want to ask in here, if you want to just pop me an email, it's absolutely fine. You can find my email address on the website. Slides, as I said, will be shared, and the recording, which I'll stop in a moment, will be made available as well. So if you've got colleagues, or if you weren't able to make it at the start, then I'll be able to share that so you can watch it later. If no one else has any other questions, I'll end this here. Thank you all very much for coming. I'll be doing another one of these next Wednesday with a colleague, which will be an update on issues in sexual abuse cases. So a slightly different topic. You hopefully will get an invite for that, and I hope to see all of you again soon. Thank you very much.